Good evening, everyone, and welcome to the 32nd Annual Silha Lecture. My name is Jane Kirtley. I'm the director of the Silha Center for the Study of Media Ethics and Law, which is based at the University of Minnesota's Hubbard School of Journalism and Mass Communication. We're very happy that you can be with us tonight. This year's lecture topic could not be more timely. Libel suits against the news media are increasing. Whether the plaintiff is Sarah Palin or Beef Products Incorporated, the manufacturer of so-called pink slime, when the President of the United States has declared the news media to be the enemy of the people and has threatened to open up our libel laws to make it easier for the powerful to sue, we have to ask the question, will the Constitution and the courts continue to protect freedom of the press? As many of you know, the New York Times Deputy General Counsel David McCraw entered the fray back in October 2016, just about a year ago, when he wrote to Donald Trump's attorney defending the Times' right to publish an article entitled, quote, "Two women say Donald Trump touched them inappropriately." Trump's attorneys accused the Times of libeling the then Republican presidential candidate and demanded that the newspaper retract the article from its website. But David McCraw refused, writing, "Nothing in our article has had the slightest effect on the reputation that Mr. Trump, through his own words and actions, has already created for himself." He defended the Times reporter's efforts to confirm the women's statements and to give Trump an opportunity to respond, and he concluded, "We did what the law allows. We published newsworthy information about a subject of deep public concern." He invited Trump's attorneys to present his case in a court of law, assuring them that a judge would set him straight. So far, Trump has not taken him up on that offer. But the president continues to threaten and deride what he calls fake news organizations, including such marginal media organizations as CNN, NBC, CBS, and ABC, along with the so-called failing New York Times and the Washington Post. Clearly, this is not a time for the media to be silent. More about David in just a few minutes. But first, I want to take a moment to say thank you. The Silha Center was established in 1984 with a generous endowment from the late Otto Silha, who was former president and publisher of the Minneapolis Star and the Minneapolis Tribune, together with his wife, Helen. Helen is with us tonight, along with her daughter, Alice Ryman, and some of her grandchildren. Helen, who's in the back at the top, we are so grateful for Otto's vision and for your continued support during the past 33 years. Thank you. I'd also like to acknowledge the new director of the Hubbard School of Journalism and Mass Communication, Dr. Alicia Cohen. We're delighted to welcome her tonight to the first of what I suspect and hope will be many Silha lectures. Alicia? Since 1984, the Silha Center has been the vanguard of the School of Journalism and Mass Communication's scholarly efforts and public outreach in the areas of media law, media ethics, and has achieved international recognition for its work. Our 3 times a year newsletter, the Silha Bulletin, covers emerging issues in media law and ethics and is researched and written by our Silha research assistants. Copies of the bulletin are available outside the auditorium, and we hope you will pick one up and take it away with you. Silha funding has supported the work of dozens of graduate and law student Silha fellows and research assistants over the years, many of whom can now be found teaching and conducting research at leading universities and practicing at law firms across the country, around the world. Our 3 current Silha RAs have all been instrumental in ensuring the success of tonight's lecture, and I would like to thank all of them for their efforts, Scott Memel, Brittany Robb, and Ashley Turchak. Tonight's lecture is the 32nd in the series that has become the Silha Center's signature event and provides a platform for distinguished and innovative thinkers from journalism, ethics, and law to share their insights and expertise, and tonight's lecture is no exception. In a recent article in Litigation magazine, David McCraw wrote that Lawyering for the New York Times is not for the shy. He recounts how his phone began ringing instantly after his letter to Trump's lawyers was posted on the New York Times website, which had helpfully posted his phone number and email address as well. Within 90 minutes, he had received 90 emails, and within 48 hours, more than 1.5 million people had read the letter on the Times website. Clearly, his letter had hit a nerve. Yet David also wrote that he considers himself mainly a transparency lawyer. He has litigated more than 35 Freedom of Information Act suits, 31 of them during the Obama administration, winning the disclosure of secret records on topics ranging from drone strikes in Yemen to the government's ever-growing surveillance program. Pursuing information about government activity through FOIA requests is essential to providing the public with the information it needs to know, he wrote in a June 13, 2017 Times essay. Unless news organizations are willing to sue when requests are denied, FOIA bureaucrats are permitted to decide just how secret our government is going to be. That was never part of democracy's plan, he wrote. David has worked for the Times for 15 years, where he has provided legal support for many of the paper's major investigative stories, including its Pulitzer Prize-winning stories on workers' deaths at a Texas foundry, the lethal aftermath of Hurricane Katrina, and the secret fortunes of China's political elite. He also leads the Times crisis management team, coordinating the newspaper's response when journalists are kidnapped or detained overseas. In January of this year, he was promoted to the position of Deputy General Counsel. David is a graduate of the University of Illinois, Cornell University, and Albany Law School. He's an adjunct professor at NYU Law School, and in 2010, the New York City Bar awarded him with its Cyrus Vance Award for his international pro bono work on behalf of free expression. So now please join me in welcoming David McCraw.
Thank you so much, and thank you to the Silha family, and thank you to all the folks here at the university. It's been such an overwhelmingly and generous bit of hospitality, given what the Yankees are going to do tomorrow. Scratch that line. Okay. So, as Jane said, some of you may have heard that I wrote a letter in October to Donald Trump's lawyers defending the right of the Times to publish a story of two women who said they had been groped years earlier by Mr. Trump. It was a particularly interesting experience for me. The Times, as Jane said, decided to post the letter online, and I was fine with that. I consider myself a transparency lawyer. I spent my professional career fighting for greater access to information and greater transparency and greater openness. And you don't really know how much you believe in transparency until your employer puts your address and phone number on the internet. There it was in the letterhead, and as the letter went out and the calls started coming in, and my inbox exploded instantly, and it was really sort of a particularly inspiring time, because there were people who criticized the letter, but the number of people who wrote and talked about how much it meant to them that I'd stood up for the Times and I'd stood up for the women was really quite extraordinary. And it ended with this paragraph that we have up here. We did what the law allows. We publish newsworthy information about a subject of deep public concern. If Mr. Trump disagrees, if he believes the American citizens have no right to hear what these women had to say, and that the law of this country forces us and those who would dare to criticize him stand silent or be punished, we welcome the opportunity to have a court set him straight. They received a lot of letters from lawyers and law professors and law students. One of my favorite came from a Hollywood lawyer, retired Hollywood lawyer, and he said, I spent my entire career writing polite responses to the jerks in my industry. I worked at a studio and I was required to reply politely. And he says, it must really be great to work at someplace where your management lets you say what you think and believe. And that raised the question for my students at NYU, who said, how does that work? I mean, did you actually get permission to send that letter from senior management? That would be a letter that used the less than lawyerly phrase piece of ass and ended with this, please sue us to the next president of the United States of America. I have a glass office, and about 10 minutes after the letter went up, I found out one of the not so great things about having a glass office is that you can see when the CEO of your company is approaching your office with your letter in one hand and a certain look on his face. In that instance, you begin to wonder whether it was such a super great idea to send a bring it on letter to the next president of the United States without first checking with senior management. So our CEO, Mark Thompson, is an Englishman. He walked right in and he held up the letter in front of me and he said, brilliant letter. But there's one thing I'll never understand. Why do you Americans insist on capitalizing after the colon? That could have gone much worse. So tonight I want to talk about the issues that Trump has raised during the campaign and during his presidency. Like no president before, Trump has both questioned our tradition of protecting freedom of the press and directly engendering a debate about our laws governing freedom of the press. It would be easy to dismiss all of that. It's not real, it's partisan, it's a way to avoid accountability, and it isn't done in a really smart way. Hashtag politics, hashtag silly, hashtag sad. But I really think embedded in there is a serious issue, and actually two issues. Because in denouncing the press, I think that Trump has legitimately played on doubts people feel about whether our system of freedom of press still works. That is there something wrong with our legal scheme that with the legal scheme that now governs the press and our understanding of the First Amendment? Have the decisions that made a whole lot of sense 30 years ago grown old? Does the First Amendment really still work in the way it's been interpreted in those great decisions from 50, 40, and 30 years ago? And I think that's a question worth addressing. The second thing is that you can't ignore that there is a receptivity to the critique, that it does have traction in a large section of society. And that's what I call the hearts and mind problem. Have we lost the public will to support freedom of the press, to see a strong news media as a positive force in society, even when we disagree with what's being said? And I think those two issues I hope to show to you tonight are related, that both that the doubts some of us feel about whether our view of press freedom, our version of press freedom really works, and this idea that there's a hearts and minds issue about whether the public still is behind the concept of free expression and a free press. The president has managed to raise questions about the very fundamentals of press law. If you are like me and you teach in this area, it's like every day is a seminar. This is so great. You know, I used to like practicing media law, but it was kind of an obscure, it wasn't antitrust, it wasn't securities laws, it was kind of an obscure corner of law. And suddenly I had currency. That's why I call this making media law great again. And, because the president has really run through the whole gamut of really important press law issues. It started with libel. Let me go forward for once. It began with this, there was this tweet: my lawyer wants to sue the failing New York Times so badly for irresponsible intent. I said no for now, but they are watching. Really disgusting. Now, those of you who are first-year law students, if you haven't got to the tort of irresponsible intent, don't hold your breath. Tort's not really a great subject for the president. My mother, of course, jumps in here. Mom's thought, oh, good, so you're against a free press, you thin-skinned mad child. Maybe they should sue you for defamation. Mom, I appreciate that. Sometimes, during the campaign, he got a little bit closer, February 2016, where he says, I'm going to open up our libel laws so when they write purposely negative and horrible and false articles, we can sue them and win lots of money. we're going to open up those libel laws so when the New York Times writes a hit piece, which is a total disgrace, or when the Washington Post, which is there for other reasons, writes a hit piece, we can sue them and win money instead of having no chance of winning because they're totally protected. Now, those of you who are following along and, or have practiced in this area know that this is actually a fairly accurate description of our current law. Right? Times versus Sullivan. If you intentionally write false articles, somebody can sue you and they can win a lot of money. It's not the most articulate expression. I'm giving that a C+, unless the person plays football, maybe a B-. But it is what the law is. And then, of course, after he won, Donald Trump came over to the New York Times, and if we're nothing, we're self-centered, we, of course, asked him, like, what's going to happen with libel? And he said there, actually, somebody said to me on that's libel laws, they said, you know, it's a great idea softening up those libel laws, but you may get sued a lot more. I said, you know, you're right, I never thought about that. I said, you know, I should start thinking about that, so I think you'll be okay. I think you're going to be fine. So it's a little unclear where we're going with libel. But the other big piece of this, of my media law syllabus he took on, and his people took on, was the idea of when we publish truthful information, can we face legal liability? And it's been sort of a hallmark in this country for about 40 years that except under extraordinary circumstances, if you publish true information, you cannot be held liable for that. And of course, the thing that struck the heart was this. Yes, the New York Times received in a brown paper envelope pages from Donald Trump's 1995 tax return, and we published them. And the reporters, I explained, look at the Supreme Court has 6 times addressed this issue of whether you can be held liable for publishing truthful information, and I assured them that was not so. But apparently the memo didn't get out very far because Corey Lewandowski helpfully jumps in while speaking at Harvard. Times editor Dean Baquet should be in jail for publishing Trump tax docs. And I'm going, wow, come on. Doesn't he know that published truthful information, you can't go to jail for publishing truthful information? I was shocked to find out that he wasn't alone. The Washington Post agreed. Now, the Washington Post, the New York Times risked legal trouble to publish Donald Trump's tax return, and there was only one thing wrong with this story. It was completely wrong. And other than that, it was fine. But it was the Washington Post. What do you expect? They don't like us a whole lot. But I wasn't happy when I saw this one. New York Times executive editor Dean Baquet says he had risked jail to publish the Trump taxes. Memo to self, have him come to the next legal seminar. And of course, very much on people's minds now, this idea of leaked information, our right to publish classified information. Even before Trump was in office, he tweeted, I'm asking the chairs of the House and Senate committee to investigate top secret intelligence shared with NBC prior to me seeing it. And more we're starting to see this idea that if the press publishes leaked information, that there should be some sort of penalty on the press or on the leaker. And I think it's important to understand the historical context of this. The basic protections of the free press in this country really arose over an incredible 25-year period between 1964 and 1989, beginning with Times versus Sullivan, the great decision that raised the barrier for people, public officials, public figures, to be able to sue for libel. And there was a whole range of decisions that followed, including the Pentagon Papers. There would be no prior restraint even when we're publishing classified information. Smith versus Daily Mail, that except in exceptional circumstances we've never seen, that the press has a right to publish true information even if someone has given it to the press in violation of a legal duty. An incredible array of press freedom. And what emerges from that body of law is that there is a philosophy of freedom of the press that is at base there, that the press is going to be protected, will be protected even when errors are made, that the press should be allowed to self-regulate through professional norms and accepted ethics, that judges shouldn't be sitting as uber editors, second-guessing editorial decisions, that more speech, not government regulation, not lawsuits, but more speech was the answer to false and harmful speech. That was sort of the scheme to it. that government was going to get out of the business of regulating free speech. And it was easy for the court to have faith in those propositions when they were deciding those cases because of the nature of the media landscape. Think of it as media landscape 1.0. Large and influential professional news organizations that dominated the flow of information. They served as gatekeepers. Newsweek, the New York Times, CBS, the Washington Post, the Wall Street Journal. These were professional organizations, and so when the court said, let the press self-regulate, let's get the government out of the business of regulating the press, it was easy to understand that you weren't surrendering this to irresponsible players. You were giving freedom to those people who took seriously their role, that played a conscientious gatekeeper to the information that flowed into society. These were organizations that had professional journalists with a shared set of norms. The government may not always have liked what those powerful media organizations were doing. They may not have always trusted them, but there was a shared understanding that powerful media was needed to check powerful government. Think of the civil rights movement. Think of Vietnam. Think of Watergate. This group of cases, this incredible array of decisions that meant so much to press freedom, grew up in what I think of as media landscape 1.0, where you had these powerful media organizations that served as a gatekeeper. That landscape is gone. Media landscape 1.0 is gone, and media landscape 2.0 looks nothing like it. It has been displaced, that is, media landscape 1.0 has been displaced by a media landscape dominated by digital communication. And it's everything that media landscape 1.0 was not. It's a cacophony of voices. There's diminished press institutions. There are no gatekeepers. Messages that go everywhere and last forever. Everybody can be a publisher in today's digital world. And sometimes that is a good thing. Sometimes that's a great thing. Think about, you remember this? The passenger on the United flight, right? Who got dragged out of that United flight. Nobody had to call a reporter. Nobody had to wait for tomorrow's paper to find out about it. People were immediately tweeting that image of that guy being dragged down the aisle of that airplane. People were immediately going on Facebook to talk about it. And that was a powerful, powerful effect. I was on a plane not long after that, and they needed somebody to give up a seat. And the flight attendant sounded like a professional hostage negotiator. We need one person to give up a seat now, and there's no pressure, and everybody started fingering their cell phones, It's really just, it's a voluntary thing. We'll give you $700, we'll give you $1,400. That's a great thing. All of us benefited from that. Other times, this lack of a gatekeeper, this lack of a dominant professional media is a problem. Let me back up here, sorry. You look at this. This was a story that my colleague Scott Shane wrote about. 23-year-old in Ohio sits down and creates this fake news story. Breaking story, tens of thousands of fraudulent Clinton votes found in Ohio warehouse. And the guy, this 23-year-old, he goes online and he finds these boxes from Brexit. Okay, spoiled ballots. Okay, now apparently people didn't, valid ballots over there. And he writes this story that in this warehouse that people have found these illegal Clinton votes. 6 million people read that story. Election officials in Ohio investigated it. That's an incredible, incredible thing. And this is where you can have someone jump in, and there were a lot of someones, not just Russians, but a lot of someones jumping in here. Guy makes $22,000 for the half hour or so it took him to make this story up. And so you start to see just how different that media landscape is. Now, so let me put the fine point on it. So we have this body of law which gives great press freedom that comes out of this media landscape 1.0, and now we have a very different media landscape. And it raises an obvious question, and it's, does that body of law still serve democracy in such a changed media environment? Can it answer today's question of press freedom and the needs of an informed citizen? Can it strike the appropriate balance between press freedom on the one hand and individual dignity national security, and the need for social cohesion. I get why people are asking those questions. I get that if you saw what happened in the campaign and the fake news stories like this, you see hate speech, you see internet bullying. It's natural that people wonder, does this system still work? And let me just take you through that, because I think when you see specifically how these things work, you start to understand some of the doubts. Start with libel, a focus of the president. You know, the basic idea of libel in this country was established in Times versus Sullivan in 1964. And it's a very simple idea. And that is that even if a story is wrong, the press is not going to be liable unless they act with actual malice, that is, reckless disregard for the truth. The idea was the Supreme Court ultimately wanted the press to be aggressive, to go out and take chances, to jump into stories, and they should not have to worry that if they get something wrong, they're going to get sued and have to spend millions of dollars in damages. The idea was only if there was reckless disregard of the truth would there be liability. And this was kind of the classic libel case, The Uncounted Enemy, a 60-minute show where General Westmoreland sued CBS. The story on 60 Minutes, some of you will remember, was about whether there was whether General Westmoreland had lied about the progress of the Vietnam War. You really see why actual malice works in this situation. CBS went out and aggressively covered this. They went out and did a lot of reporting that even if they got something wrong, they shouldn't be liable unless they acted with reckless disregard of the truth. And now you take a typical libel case today from, Courtney Love, the queen of Twitter libel. Courtney Love, the singer, holds the distinction of having been sued twice for libeling people on Twitter. That's actually twice as many times as the New York Times. We're a big organization. We're trying to catch up with her, but you know, it's hard to stay up. And she was most recently sued over this tweet, which I have, where the ... it used to have a descriptive term, which you can imagine, but I'm not going to say. And that's her spelling of devastated, not mine. Okay, so she tweets, I was devastated when Rhonda J. Holmes, Esquire of San Diego, was bought off. Whoa. Now, let me give you some context to this. Courtney Love's ex-husband, Kurt Cobain, Nirvana, left sizable estate. She hired Rhonda J. Holmes, Esquire of San Diego, to handle the estate. And in the fullness of time, she doesn't like what Rhonda J. Holmes does. And so she tweets out, I was devastated when Rhonda J. Holmes of San Diego was bought off. Rhonda J. Holmes, Esquire of San Diego, is not amused, and she sues her for libel. And you start to think, okay, well, actual malice, reckless disregard of the truth. And basically, Courtney Love got on the stand and said she didn't know nothing about nothing. That she had no particular idea about whether Rhonda J. Holmes, Esquire of San Diego, was bought off or not. She just tweeted it out there. So she wins. She wins because that's not reckless disregard of the truth. Airheadedness is sort of the ultimate sign of not having any disregard for the truth. And so you start, you start to say, is that really how Times versus Sullivan was meant to play? You then move on to one of my favorite examples here. Found to have misbehaved with pupils, but still teaching. This was the iPad version of this story. This is kind of a classic New York story where teachers who do icky things to students, touch them, say things, whatever, are not fired in New York. They're allowed to continue teaching, okay? And so the New York Times did a story about this. Now, when I called this up on my iPad that morning, I looked at this. I said, found to have misbehaved with special teaching. I thought something could have been wrong because I used to work at the Daily News in New York. That's a tabloid. So we did a lot of stories about people accused of wrongdoing. And this guy would have been a first. He would have been the first perp who ever went and got his best sweater and put it on and stood on his back deck so he could have his picture taken about misbehaving with students. And that's when I realized that's not the teacher. That's the teacher's lawyer. Oh, none of you can be on this jury, okay? Very bad, okay. Now, here's what's interesting about this, and I'm sorry this is a little distorted. That's because I pounded my iPad into my face when I saw this. But here's what's interesting about this. This is machine speech. This was created solely by a software program, okay? Let me explain. The way the iPad content is presented at the New York Times is that a program goes and grabs a headline off our NewYorkTimes.com, puts it there, grabs a picture, puts it there, grabs a story and puts it there. It has no idea, as a software program, what the headline says. It has no idea what the picture is and puts it together. What's that? Oh, there is a caption there, which also gets pulled over, and the caption helps out a little bit. It's not as clear as it could be. But most people, when they look at that, say, And the question is, how does actual malice work with machine speech? Did the software program have a reckless disregard of the truth? Did the programmer? And so you start to see, do those rules really work in the real world? So the same thing is true of national security. Here was the headline the day the Supreme Court said that the New York Times could not be stopped by the government from publishing classified information. The Pentagon Papers, new movie coming out about that called The Post. I don't know why, since it was the Times, but okay, fine. It's a very, very, very sore topic. Okay, but enough on that. Anyway, so so this was the day it came out, and again, going back to my theme, the Supreme Court, it's easy to imagine them thinking it's the New York Times. The New York Times is not going to unduly destroy national security. We can trust them. We don't need prior restraint. And you can understand in Media Landscape 1.0 that rule makes sense. But it does answer the question, if it had been WikiLeaks, would you have had the same decision? If the case that is in front of the Supreme Court was about not a legitimate, established, long history publication like the New York Times, but essentially new media, rogue media perhaps, if you think of it that way, do you feel the same way if you're the court about prior restraint? And I would raise the same question about privacy. In 1989, the Supreme Court affirmed the right of a small newspaper, the Florida Star, to print the name of a rape victim. Basically, the court held that if, in fact, it was truthful information, that a newspaper should not be punished for publishing truthful information, except in circumstances we've never seen. And in balancing the right of privacy of the rape victim and the right of the press, this court looks at it and says there is a First Amendment right to publish. There's not a similar constitutional protection of privacy. And so they are able to find that the right of privacy is trumped by the right of free expression. But it's a very different media landscape. I mean, Florida Star, a little newspaper, it publishes this, and the story disappears into obscurity. Think about how it works today. Today, that content stays online forever. Today, that content doesn't go away. It's searchable. Would the Supreme Court in Media Landscape 2.0 take a different view of it? We're all familiar with what's happening in Europe, where Europeans can go to Google and say, when people search under my name, this piece of content comes up, and it's old, it's outdated, and I don't want it following me for the rest of my life. And Google makes a judgment about whether that content should stay up. This is the so-called right to be forgotten. And we all get these notice of removals from Google search, which explains to us that someone has complained about one of our stories and that Google has decided that from now on, when that person's name is used as a search term, our story will not come back. It's understandable, even though we find this offensive, that information is being taken out of circulation. Now, you're probably saying, well, Mr. New York Times, when, what kind of stories is it? What kind of stories get this, right? Crime stories, people being arrested, those youthful indiscretions where you are celebrating your graduation by driving your car into a bar without getting out of it, those kind of stories. And the answer is the number one request is, anybody, wedding announcements. Wedding announcements, okay. Now, I have this thing about wedding announcements, okay? You probably don't know this, but the New York Times does not drive through the streets of Manhattan looking and say, oh, there's an interesting wedding there at that mosque. Oh, there's an interesting wedding at that temple. I think I'll go cover that wedding at the Presbyterian Church. People come to us. They want their wedding announcements in there. So, and you hear some really interesting stories from people about this. You know, like the person who told me, look, my children are learning to read. I took it as a good sign they wanted to read the New York Times. But my children are learning to read, and my husband and I, we never told them I was married before. Oh. So I immediately take off my lawyer hat, put on my social worker hat, and say, teachable moment. Yes, we're glad to play a part in this. But, you know, people have decided they don't want their wedding announcements up anymore because they don't want you to know that they married that bum or whatever it might be. So privacy, would it actually play out differently now? And you see it then with this whole debate about hate speech and offensive speech. And those of you who will remember when the Supreme Court actually dealt with speech that was that caused emotional disturbance, that emotional outrage, was with this. This seems so quaint, right? This was hate speech in the day. Jerry Falwell, who was a conservative minister, and was the subject of constant abuse from Hustler magazine, and Hustler magazine runs this ad about him where Jerry Falwell talks about his first time. Campari, the liqueur company, ran this whole series about the first time that somebody had tried Campari. This one is filled with double entendre, which suggests that the Reverend Falwell was actually talking about his first sexual experience. My first time was in an outhouse outside Lynchburg, Virginia, with his mother. And even though it says at the bottom, ad parody, not to be taken seriously, the Reverend Falwell sues Hustler magazine, saying that he was emotionally distraught when he saw this, making fun of him, suggesting he had sex with his mother in an outhouse. And the Supreme Court says, come on, and rules for Hustler magazine. And so, but now you look at things like revenge porn and hate speech and bullying online. Would the Supreme Court feel the same way when it's not a magazine ad, but that sort of abuse that you see online? And we could raise the same thing about a problem that was not even there in Media Landscape 1.0, fake news. What are you supposed to do about it? Now, many of you may be lapsed Catholics and may have missed this story. Pope Francis shocks the world, endorses Donald Trump for president, releases statement, and 900,000 people shared that story, okay, when it came up on Red Nation Rising, completely made up. You know, sometimes it's at least funnier. This one I love. Ireland is now officially accepting Trump refugees from America. That's a great story. That's a great story because you know the Irish would have a great, great refugee camp. Those people would know how to do that. Look how picturesque it is. But what do you do about this? And that's what, you know, this wasn't even a problem in Media Landscape 1.0. So my point here is that there's reason to ask hard questions about the interpretation of the First Amendment that we have received down over the years, and the rules of media freedom that we play by. You know, think about the communication issues that bedevil you, whether it's hate speech or revenge porn or online threats or fake news, or whether it's this idea of red feed, blue feed, where if you're on Facebook and you're a conservative, you're getting certain stories, and if you're a liberal, you're getting certain stories. should there be more controls in place? Does the marketplace work? Are individuals adequately protected? And I understand those doubts. I think the system works, and I will give you a full-throated defense of it. But I understand why people have their doubts. And I believe that is a topic that is worth debating. Because press freedom shouldn't be a religion. We shouldn't just believe it because it was handed down to us. We should believe in it because we understand it works better than the alternative. But we should have that debate. And if that's what the president was doing, was engendering a debate on that, I would say that would be a good thing. I'm okay with that. But that's not what's going on. What's going on here is what I referred to before as the hearts and mind problem. When the president says that the fake news media is not my enemy, it is the enemy of the American people, it is exploiting those doubts to try for a political advantage. When you see, and it becomes a particularly nefarious practice when you see something like this, any negative polls are fake news, just like CNN, ABC, NBC polls in the election. Sorry, people want border security and extreme vetting, but just because we disagree with it, we're going to call it fake news. The problem here is not the criticism of the news media. Criticism of the media, like criticism of any powerful institution, is an essential part of democracy's lifeblood. The problem is the nature of the criticism. Denouncing a story on CNN or the New York Times or NBC as fake news is not embracing the truth. It is just the opposite. It is asking people to skip over the analytic step of weighing what is true and what is not, and instead prodding them to simply dismiss what they don't like hearing. More than 70 years ago, the philosopher Hannah Arendt wrote about the vacuum of unthinkingness. Think about that for a while. Truth exists in the world. It gets proved to the best of our ability. Think about how trials work. One side puts in its evidence. The other side doesn't get to jump up and shout, "Fake evidence," and then get a high five from the judge and sit down. That's not how it works. The other side challenges those facts with questions and its own evidence. And out of that adversary process comes what we hope will be the truth. All of this careless tossing around of the term fake news dovetails with a related and serious problem. Think about Sean Spicer banning from press conferences news organizations he doesn't like, or Donald Trump refusing to take a question from CNN, or the White House proposal there not be any more press briefings, or the Secretary of State deciding he doesn't really want reporters traveling with him to Asia. We depend on a system of democratic norms and traditions. There are no laws that says the president has to answer a reporter's question or hold a news conference. That's probably a good thing. Those sorts of things are not easily solved with legal claims and lawsuits and judges, but there are norms and traditions about how the press and government interact. Those norms and traditions make democracy work. They are what allows the press to serve as a check on government power. I get asked all the time, well, what is it we should do about this? And I want to run a proposal that probably runs counter to the grain of what my fellow media lawyers think. Many of them think the response should be we should be at the barricades, we should be fighting this. But I think we make a mistake when we frame all of this as a battle between left and right, as painting all conservatives as the enemies of free expression and all liberals as friends of the press. In 2010, Congress passed the most significant libel law in its history, the U.S. Speech Act. It protected publishers against foreign libel suits. So if you get sued, if you're a U.S. publisher and you get sued in England or you get sued in some other country and the plaintiff wins and the plaintiff wants to enforce that judgment in the United States, the U.S. Speech Act says you can't do that, that American publishers shouldn't have to be subject to foreign libel verdicts. That was a great, great testament to free expression. It passed in 2010. The vote in the House was unanimous. The vote in the Senate was unanimous. Every Republican, every Democrat voted for that law. And if you look over the last 8 years, when there have been various bills passed strengthening the Freedom of Information Act, very important free expression piece of legislation that the government should be open to citizens and to the press, overwhelmingly, Republicans and Democrats voted for those bills. We need to resurrect that American consensus. The Times versus Sullivan doesn't just protect the New York Times. Breitbart needs it as much as we do. In fact, they need it more. Somehow, and when we stand up for free expression as a country, no matter what our foreign policy is, we place ourselves in a better place in facing down dictators and raising the hopes of supporters of democracies around the world. When we can talk about American freedom, a beacon to the world, when we can hold up the U.S. as a place where free expression is valued and protected and encouraged no matter who is speaking, that's the consensus we need to find again. Much more needs to be done. That is not the solution. But here's where we are. So we have, on the one hand, this problem of a loss of faith in free expression, the free press. We need to stand behind that. At the same time, first part of my speech, we also need to have a serious national conversation about where the lines should be drawn. Within that free expression, where are the boundaries going to be? I can stand here and tell you why I think our system works, and I'm happy to defend it, but I understand some of these doubts that people have. And we need to have that conversation about where we draw the lines on free expression. How do we protect individual dignity and have free speech on the internet? How do we have both a transparent government and national security? How do we stop the flow of toxic speech and fake news without inviting the government to become a ministry of truth? Striking that balance is going to be hard. Those are hard questions, and the answers are not obvious. But I know only two things. One is it's a discussion worth having, and the second thing is those questions won't be answered in 140 characters. Thank you very much.
Thank you. Thanks, David. So we're going to close the curtain so we're not staring at this.
I worked very hard on that slide.
Yeah, well, I know. But we don't want to distract the audience. And we're going to open it up now to Q&A. And I want to tell you that we've got two of our able Scylla research assistants, Scott and Ashley, who have microphones. And we ask that you raise your hand if you have a question, and one of them will bring the mic to you. Please wait until one of them reaches you to ask your questions. And obviously, in the interest of time, we'd like to ask you that you keep your question brief and to the point. So we'll get started. Up there at the top.
Hi, I'm John Borger. I agree with almost everything you said. I do think that you've drawn too stark a line between landscape 1.0 and 2.0, particularly in terms of the fake news or satire. I'm old enough to remember the National Lampoon / Harvard Lampoon discussion about Pat Nixon and her ideas about birth control. Tell you about that one offline.
Okay,
It's a little more off color. But I do think that rather than trying to find a legal line, that a big chunk of it is civic education and an intelligent reading of context, contextual clues, and not simply finding reinforcement in whatever story you want to have, like the pizza shop that was being run as a murder factory for the Clintons. your thoughts on civic responsibility and what can be done about civic education and from grade school up.
Yeah, and John and I will reminisce about the National Lampoon in our offline. Yeah, I mean, I think one of the that when you see what Facebook is going through and so forth with fake news, I get that Facebook should do more to help people understand it's fake news and so forth. But ultimately, I couldn't agree more, John, which is that ultimately the remedy lies with better readers, better citizens. And that's frustrating. That's going to take time. It's going to take a lot of time. But if the option is to have either the government or Facebook tell us what we get to see, I'll take as much time as we need.
Thank you for your remarks this evening. My name is Liz Fetter, and I'd like to ask a question about leakers. About the time that Jeff Sessions was going to lose his job, he suddenly said, I'm going to investigate these leakers. And I'm wondering if you could talk about what type of threats there are to the news media in terms of what may be occurring with this whole leaker investigation and whether the administration may attempt to try and prosecute journalists as well.
Okay, so excellent question. In fact, today at the Justice Department, a group of 10 journalists and some media lawyers sat down with Rod Rosenstein, the number 2 at Justice, about this very issue. And you need to divide it into two. One is the pursuit of leakers, and the other is the prosecution of journalists. In the 100-year history of the Espionage Act, and this is the 100th anniversary, no publisher, no journalist has ever been prosecuted under the Espionage Act. The Espionage Act has properly been used to go after people who are spies or people who are in government that mishandle classified information. I am reasonably optimistic that we will get another 100 years out of that without that happening. The more immediate concern is leak investigations. Now, as many of you will know, that during the Obama administration, there were 9 prosecutions of leakers, Chelsea Manning and others, and there had only been 4 in the prior 30 years. The government stepped up its prosecution against the government employees who leak. What was interesting about that was, with one exception, there was never subpoena for reporters to reveal their sources. And the government, under Obama, took the point of view that it was fine to go after the leakers, but they were going to avoid a confrontation with the press. I don't see that happening, that restraint happening with the current administration. And I do think that you're going to have those kind of unfortunate showdowns that we see from time to time, where a reporter feels the need to protect her source and is under pressure from the government to be held in contempt, to be jailed or whatever. And I think that's unfortunate because the system works. That by and large, without coming after reporters' sources, the government has been able to maintain a reasonable amount of secrecy. I think too much secrecy, but at least in their view, a reasonable amount of secrecy. The public has been able to get the news it needs. And I think upsetting the balance by taking on sources is ultimately going to be bad for the public, because if people are scared, those whistleblowers who want to reveal government waste or wrongdoing or wrong-headed policy just won't come forward.
Some of you may remember that Jim Risen, one of the reporters at the New York Times, was one of our Silha lecturers a couple of years ago. He had he was very concerned about this issue coming forward, and that was when President Obama was still in office. So it is a matter of concern. Okay, yes. We apologize that it takes a while. These steps are very steep, as you may have noticed.
Tread very carefully.
Okay. There's proposition about which I guess I understand lawyers disagree. The people use the term the press to mean the news media, the journalistic profession. But there's a theory that when the First Amendment was written, that what was intended by freedom of the press means the printing press, meaning technology for making copies. And today that would include a lot of other technologies as well. But that freedom of the press then would mean freedom to use those technologies, the printing press, freedom of the printing press. So it's not a right that belongs just to the journalistic profession, but rather to everybody. What do you think about that?
As you know, in the First Amendment, there's both the guarantee of freedom of speech and freedom of the press. And it seems conceivable, and people have written about this, that they were talking about two different types of freedom. As a practical matter, and boy, I'm going to have to turn this over to the law professors, I think that the modern court has never made that distinction, that when they write about freedom of the press, they talk about that the right is no greater than it is for any individual. So at least as the jurisprudence stands now, you really see that it's talking about freedom of expression, whether it's through mass-mediated means or speakers.
The fascinating thing is that a few years ago, a professor at the University of Texas, David Anderson, wrote a law review article and discussed how the Supreme Court had never really defined the term the press. And the reason that they hadn't done so was because they didn't need to. Right. In the 1.0 landscape you're talking about, it wasn't necessary because there was a received wisdom that the press meant anybody who was doing journalism, which was primarily what we would think of as the mainstream press. I think it's an interesting question going forward, whether the Googles of the world, whether Facebook, Twitter, are they the press? Do they enjoy the same kind of First Amendment protection under the press clause as distinct from the speech clause? So I don't think this question has been settled at this point. Other questions? Yes, over here.
Yeah, so as someone who's built a career in media law, I'm curious about your stance in regards to the gray areas that develop in hate speech. I take, for example, the Charlottesville protest that happened after the Robert E. Lee statue was supposed to be taken down. And I guess my question as a professional in the area is, where does protected speech end and incitement of violence start? And do you believe we need more universal and standardized constructs in place to define hate speech?
I'm a free expression guy, and so I believe the line is drawn appropriately, which is that to actually get over the line, it has to be that there's an imminent threat that the speech is likely to lead to immediate violence, and at that point it crosses over the line and becomes incitement. I am very, very reluctant to endorse the idea that we should follow the European lead and regulate hate speech. There's no question that hate speech does harm. I mean, there's no question about that. The question is whether the remedy would be worse, and that is having a government that decides what speech is allowable. And I guess I being an equal opportunity hater of all governments, whether it's Republican or Democrat, I just find it that's a greater threat. Again, to me, what we need is better citizens, people who will stand up to hateful speech, who will speak out against hateful speech, who will resist hateful speech, counter-protest, and so forth. I think that's a better system. Obviously, in Europe, whenever I speak there, I'm constantly confronted with what they think is a nutty system. They think that there are rules that can be drawn that can decide what's hate speech and what's not. And I'm just not that optimistic about government being able to do that.
But the Supreme Court ruled that unpopular speech is constitutionally protected speech.
Right, right.
The Supreme Court ruled that.
Yeah, and I agree with that.
Well, then hate speech is constitutionally protected speech.
That's right. That's precisely the point I was making.
It's a pleasure to see a fine lawyer. I hope you keep talking. You're a great role model.
Thank you.
This is a legal nit. I heard your piece on NPR today, and you were saying that after the Billy tape, you published 2 stories by women who came forward and said they'd been groped. And you said, well, Trump threatened to sue us. I guess that was your famous letter, Bring It On. But you said, well, even if it was false and was libelous, they have to show damage to the reputation. His reputation was so bad that it couldn't get any worse. Well, you know, wouldn't it be a victory for the Trump folks if he were to sue and the finding was, yes, in fact, it was false. The Times published a false story, even though there's no damages.
Yeah, and the capstone of what I said there was that you always want to win on truth. The question was why I had included the paragraph which Jane so kindly read about that our story didn't have any effect on Mr. Trump's reputation because he had such a bad reputation in this area. I was writing to another lawyer. I was taking seriously the idea that they were threatening a lawsuit, and I was laying out the kind of defenses that we would have. You know, obviously, all of us would like to win on the basis of truth. And sometimes that's expensive, and sometimes it's not always clear to a court, so you try other defenses. When Donald Trump sued my friend Tim O'Brien over his book Trump Nation for libel, Tim ultimately wins on an absence of malice. Just very briefly, Tim O'Brien writes a book called Trump Nation. There's one passage in there that Trump sues him over, and it was a passage that said that Trump may not be a billionaire. Okay, and that crossed the line. So he sues Tim over that passage, and Tim wins on the basis of actual malice, and it allows someone like Trump, who wins on that basis, to say, well, the court would have found the story false, and Tim won on a technicality. You don't really want that. I mean, you want to be able to say your journalism stood up.
I think if I could just make one observation, because I talk about this in my undergraduate media law class a lot. It's really central to remember that libel is not just about truth or falsity, full stop. You know, that's not all we're dealing with libel. This issue of did it harm the reputation is a critical aspect of that, because if that's not part of the calculation, if it's not part of the calculation that we go through, then essentially you are creating what you referred to as the ministry of truth, where the courts are deciding truth and falsity just in isolation. The key to libel is, did it harm your reputation? And so I think that question of whether this was really going to be harmful to Donald Trump's reputation was an absolutely fair one to ask and a critical question to ask.
Right, and I also think with Trump threatening to sue, that at some level this is a political campaign, right? And the remedy for that is to go on Twitter and denounce the New York Times, denounce the women, make speeches and so forth. That's how the system works. In the middle of a political campaign, especially a high-profile political campaign, is not the time to be sort of contemplating, who can I sue and who can't I sue. It's the time to be having a robust and sometimes zany political discussion, and that's what was going on, and that's how it should have been handled.
I wonder, though, and you kind of alluded to this. It seems to me that the constant litany of fake news, they don't believe anything they say, is really very concerning. And I think President Trump has touched a vein in American consciousness. He didn't create it. He's exploiting it. And I think it was the attacks on the press coming from the right as well as the left that made it possible for him to capitalize on this. At least that's what it looks like from where I sit. And so to reduce this just to a left versus a right thing, I think it misconstrues what's really going on here. What I think is really going on is a deep public distrust
Right.
of the news media to a degree that we haven't experienced in this country for a very long time. There was certainly a crazy time in American history where the press was very partisan and so forth, but the level of distrust, I think, is so extreme now that I don't know how we get it back.
Right, and as I said in one of the radio interviews today, that it doesn't matter how much freedom the press has, how much protection it has, if it's not believed. If it's not believed, you can have a completely free press, and it's not helping the public, and it's not serving as a check on government. And it has become an easy one. And I received a letter a couple months ago from a very, very fine lawyer at a very, very fine law firm who was unhappy about the coverage of one of his clients who was a businessman. And in the middle of this letter from this very fine lawyer from a very fine law firm, he says it's fake news. So I call him up and I said, did you really say, he goes, I'm so embarrassed, I'm sorry. It was for my client, of course, but it became so easy as sort of a throwaway line, and somebody who knew better than to do that. The one cultural thing here, which, and I don't know how to make of this, I was in a gift shop in Albany, New York, the state capital, and I see this athletic pennant, which would have like Vikings on it or Eagles or whatever, only it had fake news. And I thought, there's a whole team out there for me someplace. I want to go to the gift shop owner and say, who else bought these? Who else bought these? I have no idea what that means.
Was it written in Cyrillic?
It was kind of done in ISIS colors, black and white.
Okay, other questions? Yes. Somebody down here?
One of the important functions of major news organizations is holding corporations accountable in commerce. How concerned are you about what appears to be a very large settlement in connection with the so-called pink slime matter, where ABC may have paid somewhere in the neighborhood of 10 figures? And do you think that will be a deterrent to major news organizations' willingness to take on corporate interests?
I thought that was a very, very troubling outcome. We know that in the pink slime suit that the corporate plaintiff got $173 million plus insurance, and that must be a big number. And I do think it gives pause. The one thing that I put as a footnote is and maybe Jane has a view on this, it seems so out of proportion, it's hard to know what lesson to draw, what happened in that case. And I was talking to those lawyers for ABC, and they were very, very bullish about their case, and the next thing I know, it was settled. But if it's a straight-up libel case, I do think that even if it doesn't intimidate the media, I think it emboldens corporations to sue. And we have not seen a lot of that over the last 20 years. Corporations have been unwilling to jump in and file libel suits, generally speaking. Not always, but generally speaking.
I agree, because I was telling David earlier that I had been in touch with one of the lawyers for ABC after I had done an interview with NPR when the trial was first starting, and the email I got from him said, this is a ridiculous case. And I said, and I agree, and I think you're going to win, and I think you should persist. And then a week later, we suddenly find out that they've settled the case. And there were probably many reasons why that decision was made, but I think the message to corporate America is, you can bring them to their knees if you persist. And when you couple that with the cases of Jesse Ventura's case, the Hulk Hogan case, a whole variety of other cases, the landscape doesn't look as favorable as it did a few years ago. And this may all sort itself out if enough of these cases go up on appeal, but of course, when they settle, they don't get appealed, so you're left with that sitting there. We probably have time for a couple more questions, so Bill McGovern over there, and you, sir.
I'm not sure if the questions are separable or not. Um, the talk you had titled here is Making Media Law Great Again. Is the media itself in danger, or is it media law that's in danger here?
I think the media, not media law. I, mean, I don't spend a lot of time worrying that the law of libel is going to change or any of this thing. I actually think that those precedents are pretty strong. I do think, though, that there are a variety of forces that are undermining what I'm going to call the mainstream news media. It's financial. While Trump refers to us as a failing New York Times, and we're not failing. Thanks to him, we've actually had the biggest growth in subscription in a long time. But it's a challenging ad environment. Put aside whether you want the news, it's a challenging ad environment. I think the level of distrust that Jane and I have been talking about is real, and I think that the president's comments have essentially exacerbated that distrust. I think the situation with local journalism is truly scary. A lot of people in this country live in cities that are essentially journalism-free zones now, and people are looking at ways to change that, but that's scary. I mean, that's scary to look at places where the newspapers have fallen on such hard times that they aren't really doing basic reporting, what the school board is up to, what the city council is up to, what the mayor is up to. So I do think that the threat is really against the media more than against media law.
And I just would observe that when you were talking about the golden years of media law, the vast majority of those cases were brought by or brought against mainstream media organizations, and who had the money and the wherewithal and the spirit and the guts to fight all the way to the Supreme Court. And although certainly there are still some news organizations like that, there are fewer and fewer of them. So that is the other question. Who's going to carry the flag? You know, is Facebook going to carry the flag? Is Google going to carry the flag? I'm not confident that they will do that. I mean, they certainly litigate in cases that are of interest to them, like the right to be forgotten, things that David was talking about. But I don't see them as the great crusaders who will believe in the First Amendment as a positive good and not just a good business decision for them. But we shall see. Bill.
So a lot of the rules that you've talked about, like actual malice, when they were written as being about matters of public concern or limits on the privacy toward or around being newsworthy, things like that. But in what you describe as Landscape 1.0, that was pretty circular, right? The New York Times only printed what was fit to print, and so no one ever had to think about what that meant because everything the New York Times, by definition, printed was newsworthy. So in 2.0, not so much, and there certainly has been some interest in reanimating newsworthiness doctrine. Is that a path to a solution, or is that a path towards a different way of bringing in the same problems of government involvement that concern you?
I would go with the latter. I mean, it's a really interesting question that you know, if should there be greater protection for what a court designates as newsworthy, and at one time the Supreme Court started to head there and then sort of reversed course, that I am concerned that the definition of newsworthiness itself can be a tool for courts to turn off protection for information that most of us would find useful. We certainly see that in other areas of the law, for instance, in commercial speech cases where the question is someone's name and identity being used in a commercial way or in a news way? If it's a commercial way, they're entitled to money. You're using them to promote a product. If it's newsworthy, not so much. And if you look at those cases, there's just so much confusion about what is newsworthy. I mean, what does that mean? Does that include works of art? Does that include works that would have a very narrow audience, or does it have to have a broad audience? And so it's tempting to have that thought, but I agree with the last part of your question. I think it actually it just invites greater court scrutiny and court control.
And I would just make the observation that when you think about something like the right to be forgotten, which is about suppressing the truth, it seems ironic that there would be this campaign to try to adopt that at a very time when people are talking about fake news. Let's suppress the truth so that it'll be even easier for people to promote fake news. Seems to me that's a dangerous situation and a dangerous path to go down. Well, I thank you all. Thank you, David.
Thank you.
And please, everybody, join me
Thank
in
you.
thanking David again.
Thank you.
I'd like to encourage you to fill out one of the comment cards in the program. Let us know what you think, and we hope you'll come back and join us for the Silha Lecture next year. Good night.